This one has the Bill of Rights in it, so stick around, although a bit of expectation management, I'm only going to mention it. But I hope you find this interesting. Juryless trials. There's a really good blog, Magistrates Court blog, by somebody who works within the system, and they do really good sort of reports on what's happening. And they tipped us off about this plan for juryless trials. And just about to do a video, Dan did a really good video on that, so I'll put a link in the description to that. But I know you all like a bit of legal trivia, so I thought what I'd do is just look at the concept of juryless trials generally, and specifically I want to look at Diplock Courts and the Star Chamber. So first of all, I mean, do you have a right to jury? I mean, people go on about Magna Carta, and it does say in there about, you know, you have a right to be tried by your peers. But obviously, of course, we have magistrates' courts and stipendiary magistrates, or district judges as they are now. You know, and they can make decisions in criminal trials, and, you know, they're not really a jury, are they? You only get juries in what we call indictable or either way offences. Summary offences are ones that can only be tried in the magistrates' court. Indictable offences are ones that can only be tried in the Crown Court, and either way offences, as it suggests in the name, can be tried in either. And for that to happen, first of all, the magistrates have to say, yes, we accept jurisdiction, but then it is up to the defendant. They can say, okay, I'd like to stay in the magistrates' court, or they have an absolute right to elect jury trial. But that's not always the case. So what were the Diplock Courts? These are something that we had in Northern Ireland. And the worry there was, because of the Troubles, that there were perverse acquittals, and also there was jury intimidation. Now, the thing with perverse acquittals is, I mean, I've done a previous video on Bushell's case and, you know, the right of a jury to say, we don't care what the judge says and what the evidence is, we do not want to convict these people. And there's a big debate as to whether it's a power or a right. But the fact is that juries can do that. A jury can come back and say, we don't care how strong the evidence is, we acquit this person. And that was happening in Northern Ireland, but also there were worries about sort of jury intimidation. So they introduced something called the Diplock Courts. Now, we call them Diplock Courts. It was more of a procedure. They still sat in the same court, you know, physically the same courts. But that created a list of scheduled offences that could be tried without a jury. And indeed, the standard practice was it wasn't a decision. If it ticks one of these boxes, then it will be tried without a jury. And they were the common law offences of murder, manslaughter, arson and riot, and various statutory offences such as malicious damage, offences against the Persons Act, Explosive Substances Act, because, you know, this was the Troubles. And also, you know, there were grounds for adding others. But generally speaking, if it was one of those offences, then it would go to a juryless trial. However, there was a procedure where the Attorney General could say, this clearly isn't political. You know, this is not a political thing. This is just basically a punch up in a pub or a stabbing or something like that. In which case, he could say, no, we won't apply the procedure. You get your full jury. Now, what's really interesting about this is you sort of say, oh, it's a juryless trial. How fair is that going to be? That, you know, you don't have a judge of your, you know, a jury of your peers. But what's quite interesting is the Diplock Court, the conviction rate in the Diplock Courts was 51%, as opposed to with juries where it was about 49%. So arguably, that's within the error bars. There wasn't that much difference. Look at this, I actually made some notes. And when I say made some notes, I just cut and paste from articles by smarter people than me. That's all gone now as part of the Good Friday Agreement. However, there is still a procedure that applies in Northern Ireland and indeed in England and Wales. Over here it's Section 44 of the Criminal Justice Act 2003, and that allows for a trial without a jury where there's a serious risk of jury tampering. So theoretically, even here, you know, you can be tried without a jury. I mean, it's not, also, you've got to put some evidence in and say, look, this is the reason why we say that there's a risk of jury tampering, not just because, oh, you know, they're villains, they must do it. It gets a bit complicated because then you have to, you know, it's all with the judge and stuff, and it's like, you know, I mean, the judge obviously won't be prejudiced by the fact there isn't a jury. And it can get a bit complicated because of, you know, you might have a mixed indictment where you've got these offences and different people, and people go, well, I'm being charged as a co-defendant, and there's no suggestion I would tamper with the jury. I want my juror. So sometimes we'll go for what we call severance, which is we want to all be tried separately. But what about the Court of the Star Chamber? Now, that's got quite a sort of bad reputation in history. But first of all, it ran for a very long time. And it's a bit confusing as to exactly what the Star Chamber was. But originally, it started out as a sort of an alternative appeal court. And I've mentioned before that, you know, you have the common law, and most procedures in this country operate under common law, so including criminal trials. But then people say, well, the common law can produce very harsh, unjust results. It's very rigid. Because there was this sort of tension between, we want certainty in the law. You know, people need to know what they can and can't do. People need to know how the law works. You know, I mean, now that's enshrined in the ECHR. You know, offences have to be down by law. You have to know exactly what you are and aren't allowed to do, and you have to have at least a theoretical possibility and ability to find out what offences are, whether that's looking at the statute or ploughing through the case like law reports. But it's not like in the old days, pre-ECHR, where courts could say, you are being prosecuted for this. It's like, for what? Well, since when this has been an offence? Oh, well, it's a common law thing, so this has always been an offence. You just hadn't actually noticed it before. Because, you know, in common law jurisdictions, judges do not make the law. They merely interpret or discover the law, but the theory is it's always been there. What you could do if you were unhappy with a decision a common law court came to in like a civil case, you could appeal to the Lord Chancellor, as I've mentioned before, the keeper of the King's conscience. And they would try and find an equitable result for you. So it's like, yes, the common law as applied has produced a very harsh result that isn't fair. So I'm going to step in and, you know, change that. And eventually we ended up with separate courts of equity that you could use, you know, almost as an appeal court, but they ran parallel to each other. But then we had something called the Judicature Acts, which got rid of the separate equity courts, but allowed just the regular old common law courts to also consider equitable remedies as well. But even then people said, well, it's all right, but what about us poor common people and stuff? It's all right having juries and, you know, judges and stuff, but, you know, the great and the good and the wealthy and the powerful, it doesn't matter because they, you know, no jury is going to sort of convict the guy who owns the house that they live in, you know, the sort of manor of the, you know, the lord of the manor. And also, you know, judges and magistrates, they can be just as easily intimidated by powerful people. So the actual Star Chamber came along, and originally it was sort of just a committee of very senior judges and members of the Privy Council. It sat in the Palace of Westminster. And originally it was to deal with, you know, where cases were unfair and unjust, and the law just was inadequate, whether that was through common law or equity. They could say, no, we are going to find a remedy. And it was literally described as a court for the poor people. You know, it listened to what were called poor man's causes. In other words, you could go there and say, look, I am being shafted because I can't afford clever lawyers, or I'm just some serf and nobody cares about me, so nobody dares sort of rule against, you know, the powerful person that's suing me, or I'm suing. Or in a criminal case, the person who is like, you know, they're not going to pretend to disbelieve the, you know, powerful people's witnesses if they say that I did this offence. So you could go to the Star Chamber. And the idea is these were people who were so senior and so powerful themselves that they couldn't be intimidated or bribed or swayed. And they could come to an independent decision. And that was pretty much how it started. And then eventually it went from being an appeal court to a court of first instance. People could just say, right, I've got this issue. There's no point me trying to deal with this in the regular courts because I'll just get shafted. Can you deal with the case, please? And that ran for a very, very long time. However, and this is the thing, they said, well, if you've got this power to totally ignore the law and just put whatever remedies you think are appropriate there, you know, in the interest of fairness, well, what about if the law is inadequate in convicting people? What if somebody does something wrong, but either, again, they are too powerful and too wealthy to be prosecuted, or the law just doesn't, you know, they can wriggle around the law. They have a legal defence to this, even, you know, if it's not a very, meritorious one, but they've got the clever lawyers. So the Star Chamber said, okay, in the same way that we can just impose our will to acquit people or to find in favour of, defendants or potentially, we can also, if we think it's in the interest of justice, we can convict people. Okay, there's no offence that covers what you did, and indeed, there's no way we'd be able to persuade a jury you did this or persuade a judge you did this. However, we find that, in the interest of fairness, you should suffer some penalty or some consequence for this. And that is where it all started, where the Star Chamber got its really sort of like bad name, because it was, it was completely arbitrary. It could just sort of say, oh, you've been fingered for something, we think you're a terrible person and we think you should suffer this consequence. And then the argument is that got misused and it sort of went away from its original origins and it just became a tool of oppression itself. There's all sorts of, Google Star Chamber, there's all sorts of fascinating cases there. Eventually, it was actually abolished after it sort of ran till pretty much the end of the Civil War. Again, the Roundheads and the Cavaliers won and the Long Parliament and all that sort of thing. So they got rid of it. It has had quite an influence on law, though. I mean, I mentioned before there was English barristers wrote the American Constitution, and they were specifically very aware of the Star Chamber. And that's why they explicitly put the right to silence in the American Constitution, the Fifth Amendment, because arguably, although there was always a right not to self-incriminate at common law, and indeed, actually, defendants weren't actually allowed to give evidence for a long time, because the argument being, there's no point listening for you, you're biased. You're just going to say you didn't do it, so there's no point you giving evidence. They could make an unsworn statement from the dock, where they could say, look, okay, there's a trial, can I just chip in now? But the juries were told, well, okay, they're just saying that's from the dock, they haven't sworn an oath, and they're not subject to cross-examination, so give it such weight as you think fit. I mean, it's amazing how we have changed from you're not allowed to say anything to now you must say anything. But it's because of the Star Chamber, because the Star Chamber had a rule which was effectively you were compelled to answer any question. And if you didn't answer it, they could draw adverse inferences from that. That sounds familiar, doesn't it? It was abolished, but it had this big influence on American law. I suppose people are also saying, why is it called the Star Chamber? Well, there's lots of etymologies put forward to do with sort of, it meant this word and it was this word in Yiddish, or it was this word in Hebrew, or it was this word in Norman French, or it was this word in Norse. I personally subscribe to the very simple theory that at the time, when it was first established in the Palace of Westminster, the committee room they used, a popular form of decoration back then, was just to sort of paint your ceiling dark blue and put stars on it. That was a really common thing to do, and the particular committee room that they used actually had stars on the roof, and that's why they called it the Star Chamber, which is part of the reason that we get the confusion, because they just use that room generally. So lots of committees sat in that room, so arguably they were all the Star Chamber. It's funny now, because I did my only House of Lords case, and it was the House of Lords then, and that's when it was literally the Judicial Committee of the House of Lords, so pretty much the subsequent, successor to the Star Chamber. But you just did it in a horrible committee room down this, just at the end of this corridor with a really tacky carpet. Now, of course, they're the Supreme Court, and they've taken over the old Middlesex Guildhall, Crown Court. And, they've got a much better carpet. It's actually Peter Blake who designed the carpet. And I keep writing to them and emailing them going, look, if you ever get rid of that carpet, can I have it? Or have you got any offcuts? And they never get back to me. And some just say, well, maybe that's because you never start an email with, look, I'm not a crank, but I'd really like that. But they have really improved the carpet. And I do miss the old Middlesex Guildhall, because I used to hold a record there for fastest ever trial. It's a bit of an unofficial record, but it was really good, because I think the trial lasted for 47 minutes, and then the jury out for 2 days, and in the end it was a hung jury, and we had to have a retrial. But anyway, that's probably enough rambling. Sorry, I literally just got back from the pub. But as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. I'm trying a different lens today, so hopefully I'm not quite as beaky. But let me know in the comments if that is aesthetically better. And I've got the boys, and to avoid all the fighting about which side they sit on, they're currently agreeing to sit on the same side. Speaking of which, I'm now going to move across because I need my YouTube thumbnail and I need to be on this side of the screen to do it. So I'll just stand there. Please ignore me while I just sort of pull some faces. Star Chamber. Ooh, interesting. Juryless trials. Smile a little bit. Look up at the title, which I haven't even thought of yet. You get the drift anyway, don't you?
And as I'm editing this, I've just remembered I forgot to actually mention the Bill of Rights, but suffice it to say, after the abolition of the Star Chamber, there was mentions in the Bill of Rights, effectively, to make sure there never was another Star Chamber. And that's where you get sort of like, some of the rights about, you must be entitled to be tried fairly and all that sort of stuff. Yeah, sorry about that. I'll stick that at the end of the video.